Hello, everyone. Welcome to Skip the Core Drama, out of course solutions for a more affordable and kinder divorce. I am delighted to have you all here today as we explore alternatives to traditional courtroom battles in divorce. I will talk for about 30 minutes and have a Q&A at the end. So if you have any questions, please type them in the Q&A section. My aim with this presentation is to explain why avoiding court litigation can be beneficial for you, why the use of non-court dispute resolution has become more important than ever, and to give you an understanding of the available options so that you are empowered to make informed decisions, giving you greater control over both the process and the outcome of your divorce. But first, a bit about me, especially for those of you meeting me for the first time. Who am I? I am a certified professional divorce coach, a practicing family law solicitor, and I have 20 years of experience helping individuals and families with a separation, divorce, and family matters. I am a busy mom of two teenage boys, originally from Spain, and I have been living and working in London for the past 23 years. I am an ambassador for an amicable and kinder divorce where the needs and well-being of the family take center stage. Hence, my delight to be able to talk to you today about non-court options so to reach a fair and positive outcome without undue acrimony. Let's start by addressing first the three fundamental components of divorce. The dissolution of the marriage is the actual divorce itself. Legally terminating the marriage involves making a divorce application and following a prescribed process to obtain the order from the court to show that you are divorced. Since the implementation of the no-fault divorce in April 2022, so 2 years ago, the procedure has become straightforward, often not requiring legal representation. However, it's important to note that this process only deals with the dissolution of the marriage and does not address financial or child-related matters. The second is the children arrangements. If you have children under 18 in full-time education or requiring long-term care, you will need to reach an agreement regarding their care and financial support. Typically, these arrangements can be outlined in a parenting plan, negating the need for court intervention unless disagreements arise. And the third one is the financial arrangements. As I said before, the divorce application only ends your marriage. It doesn't resolve any financial matters. And a separate application is necessary to obtain a legally binding financial order from the court to sever the financial ties between you. This application can be a paperwork exercise if you have both reached an agreement on how you will divide your money and property and where you will both live. So the big and common question that many of you ask, will I need to go to court? Not every relationship breakdown leads to court. In fact, most do not. The truth is, many cases can be resolved without setting foot in a courtroom. There is an array of non-court options available, as I will show you in this presentation. Despite common misconceptions, court involvement isn't always necessary for addressing financial and childcare matters. Many mistakenly believe that litigation is the sole avenue for justice or achieving optimal results, but those who have gone through court proceedings and the family law professionals know that this is not the case. Moreover, rushing into litigation often escalates animosity and expenses. Court proceedings can be emotionally taxing, risky, and expensive. While there are instances where immediate court action is necessary, that is only in a small percentage of cases, such as matters involving jurisdictional issues, urgent orders, or to protect a person or an asset that you think or know your spouse is putting out of your reach. But once the asset is protected, you might consider using one of the non-court options if appropriate. But why should you even consider avoiding court litigation? Well, to reduce stress and conflict. Non-court dispute resolution also tends to be swifter and more cost efficient, and some solutions can promote better communication and collaboration, fostering a more amicable resolution, and to keep your family affairs private. Going to court should be considered only as a last resort when all other avenues have been exhausted. As I will show you, you have other alternatives. The court option should only be activated in circumstances where there is simply no choice. If you can avoid going to court, the chance of keeping your divorce amicable is generally much better. But there is one more reason. The family procedure rules are being amended, and the new legislation will come into force in a few days, on Monday, 29th of April. This strengthens the requirement that every case be resolved away from court where appropriate and possible. The new Part 28.3 states that in deciding whether to make an order in financial remedy proceedings that one party pays the cost of another party, the court must have regard to any failure by a party without good reason to attend a mayam or to attend non-court dispute resolution. Therefore, it will no longer be possible to say that the case is unsuitable for non-court dispute resolution without very good reason. But what does non-court dispute resolution mean? Part 2.3 defines it as methods of resolving a dispute other than through the court process, including but not limited to mediation, arbitration, evaluation by a neutral third party, and collaborative law. A MIAM is an information meeting with a trained and qualified mediator. Although it stands for Mediation, Information and Assessment Meeting, mediators conducting the MIAMs have to consider and explain not only the potential benefits of mediation, but also other methods of non-court dispute resolution, and indicate which forms of may be most suitable for resolving the dispute and why, and provide information about how to proceed with the services in question. Given the coming changes, expect to be directed to attend a MIAM unless you are able to negotiate directly with your spouse or are already using a non-court dispute resolution solution. In this presentation, I will explore the following non-court options. Given the time available for this presentation, I won't be able to go deep in detail into every option, but I will aim to give you an overview, examine some of the benefits and drawbacks, and share some tips to guide you and help you select the suitable process which best meets your needs and circumstances. But first, what do all the non-court options have in common? They are all voluntary and require mutual agreement between you and your spouse as the best way forward. They are completely bespoke and can be combined to create a tailored system that reflects the unique circumstances of each family. You can pick and choose what will suit and assist you in your journey. And 2 tips for all the non-court dispute resolution options. You need to be emotionally ready to make decisions. In order to progress amicably, it's important to acknowledge where both you and your spouse are emotionally. You both need to agree that divorce is the only option, even if one person doesn't want it. Where are you in the grief journey? Ask yourself, do you need support from a divorce coach before taking any action? And the second tip is that unless provided within the service, don't skip taking legal advice about your rights, responsibilities, and your situation in particular. And at the very least, before the proposed outcome becomes a binding agreement. Under English law, there is the no order principle with respect to children's arrangements, which means an application to court is only necessary in the event of a conflict. For this reason, my perspective will be primarily on financial matters, but many of these options can also be applied to children's arrangements. And another tip, to achieve fairness on any option, there needs to be full and honest financial disclosure. That's a starting point. Then it is just a matter of how to distribute the pot. So now let's move on to talk about the different non-court options. The first one is DIY, couple negotiation. This is where you negotiate your own agreement on how to share your assets and money and how to care for your children with or without professional support, deciding what is best for yourselves based on your knowledge of each other's needs and those of your children and your financial circumstances. It can be the cheapest way. However, it is not suitable for everyone. You can also DIY with strategic advice and support from a family law professional in the background to ensure that you understand your rights and the full implications of any agreements and decisions that you make. I do recommend that you do this. Once you come to an agreement, you will need a lawyer to convert the financial agreement into a consent order to be lodged at court for approval so that it is legally binding. Without a court order, your claims against each other remain open even after death. So when does this work, the couple negotiation? It may work if you and your spouse remain on good terms, communicate well with each other, and trust the other sufficiently to be honest with you. And what you need to watch out for? Well, you shouldn't feel under pressure or control. That full and honest financial disclosure is provided, and I suggest that you record your conversations as without prejudice before an agreement is reached. What are the three top benefits? It's the cheapest and quickest option if you are broadly in agreement. You are in absolute control of your own outcome, and it's the most amicable option. Now, one professional, one couple, which is also known as one lawyer, one couple, or one lawyer, two clients, or solicitor neutral. This is where you freely choose to work together as a couple with a family law professional or a lawyer who will not only help you with your discussions and negotiations, but also guide you through the process and complete the necessary paperwork. The professional provides legal information, but not advice, so remains completely impartial and neutral. The advice can be facilitated by obtaining a joint neutral opinion or evaluation from a lawyer. If valuations or expert advice is required, this is facilitated by obtaining joint reports. All the discussions are without prejudice and therefore cannot be relied on outside the process. When does it work? When you are both committed to cooperate in reaching a fair agreement, to be respectful to each other, to full transparency and disclosure of relevant information, to proceed consensually and without co-litigation, and to put the needs and interest of the whole family first. Things that you need to be careful is that it is not appropriate when there is high conflict, power imbalance, or domestic abuse. And again, you shouldn't feel under pressure or control, and full and honest financial disclosure needs to be provided. What are the three top benefits? You are in control of the outcome and the timetable. It's a bespoke service and it's cost effective because usually a fixed fee and you have certainty about cost and you share the cost of other professionals and experts. If it doesn't work, then you can explore arbitration. Neutral evaluation. It consists of obtaining a joint neutral opinion from a lawyer. This can be in person, online, or in writing. You might use the neutral evaluator to give you an overall view of the matter, like what might happen if the court was asked to make a decision, or to deal with specific issues where there is a disagreement. You are not compelled to accept the view of the neutral evaluator, but it is likely to be a good indicator of the potential outcome, and it is not legally binding. When does it work? It is a great resource at all kinds of pivotal moments in any negotiation. It can be used as a standalone remedy or be brought into the other non-court resolution options where an impasse has been reached. What you should watch out for, you need to ensure that the neutral evaluator is given a fair, honest, and complete picture. The top three benefits is that it can be inexpensive and quick to arrange. You can negotiate a fixed fee, and you also have the ability to choose your neutral evaluator. Solicitor negotiation is when either of you instruct the solicitor to write to the other requesting the financial information and then negotiate through correspondence or at a roundtable meeting. This can work when you're having trouble communicating with each other and you need the solicitor to communicate on your behalf, and also when there is a level of mistrust. What you need to be mindful of is that you need to choose the right lawyer who takes a constructive approach and does not build the animosity. It can sometimes lead towards court litigation if negotiations fail, depending on the lawyers. The dealings via correspondence can be costly. It may be that your spouse does not engage with your solicitor, and it also tends to be positional rather than solution orientated. I would say that the top three benefits are that you are guided throughout, you are receiving legal advice, and the financial disclosure will be scrutinized by the lawyers. If this method doesn't work, you could get a neutral evaluation or consider a private FDR or arbitration. The next option is mediation, where you will have the opportunity to engage directly with your spouse under the guidance and assistance of a trained mediator. The mediator's role is to facilitate constructive dialogue, guiding you towards a mutually acceptable agreement. The mediator acts as a neutral party, ensuring a smooth and impartial communication without taking sides. The mediator only provides legal information, but not advice. All the discussions are without prejudice, meaning they are confidential and cannot be relied upon outside the mediation process. Any agreement reached isn't binding until you have had the chance to seek legal advice. You retain the flexibility to withdraw from the process at any point if mediation breaks down or if you wish to discontinue. Sessions can be conducted face-to-face or online, catering to your preferences and the mediator's location. You can have as many sessions as you need, but obviously there will be a cost. You also have the choice of being in the same room or using shuttle mediation, where you and your spouse remain in separate spaces throughout the process. Although it is more time consuming, shuttle mediation can be suitable for situations involving domestic abuse or where being in the same room feels intimidating. For cases of high conflict or abuse, and therefore potentially suitable for almost every case, there is also hybrid mediation, where the mediator can hold confidences and you can confidentially share your concerns with the mediator while in a separate and safe space supported by a family law professional. If you cannot have your lawyer with you, consider having them available on the telephone so that you are only charged for the time involved in receiving the advice. Even if you have made progress in reaching an agreement independently, mediation can assist in resolving any remaining issues. It's a flexible approach that can be used at any stage, including during ongoing court proceedings. There is also child inclusive mediation, where a mediator meets with a child to ensure their voice is heard when issues relating to them are being discussed by their parents. Mediation and one lawyer, one couple method are actually good forums for the construction of parenting plans. Lawyers can be involved to such greater or lesser extent as suits you and your spouse in any form of mediation, not just in the hybrid mediation model as many think. You have the choice to involve a family law professional or a solicitor either in the background, guiding and advising you behind the scenes. Although if your spouse does not want a solicitor, they are under no obligation to have one, or directly in the mediation process. Financial assistance, such as the Family Mediation Voucher Scheme, may be available to support your mediation journey, and legal aid is only available for domestic abuse matters. What you need to watch out for. There needs to be full disclosure. Without full disclosure, you cannot have proper discussions to reach a fair financial settlement. This can be dealt with before starting mediation with the assistance of a family law professional. It won't work if you are not willing to enter into a proper discussion and be open to a compromise to reach an amicable agreement. The mediator won't tell you what to do and will not give you legal advice. As it is not legally binding, it is possible for either of you to change your mind, wasting time and money. However, this can be avoided by signing up for arbitration. I would say that the top three benefits are that you are in control of the outcome. It can help improve communication between you and your spouse, which can support your co-parenting relationship after the divorce, and it is a supportive environment. If mediation is not successful, then consider obtaining a neutral evaluation or using arbitration. In family arbitration, you appoint an arbitrator as an independent adjudicator who will make a decision that will be binding. Arbitrators are usually ex-judges, senior family law barristers, or solicitors. An arbitrator can either on paper or at an oral hearing decide all the issues in the matter or simply those issues which remain outstanding and you are stuck on. Joint instructions for the arbitration can be provided by the lawyers or the mediator, especially if neither you or your spouse have solicitors involved. And you can also self-refer to arbitration after the change of disclosure if you don't have lawyers and you are not involved in mediation. And you want that adjudication, but you need to bear in mind that the arbitrator can only provide direction and information and not legal advice during the process. Arbitration is voluntary. You must agree to engage in this process, making it a joint decision. Before committing, you would attend a pre-commitment meeting free of charge as an opportunity to consider how the arbitrator might be able to help and what might be required. However, once you are signed up, you cannot withdraw and are bound to the process. Whereas in mediation, either of you can say a stop at any time and it is not binding. The arbitrator will make a decision for you both, just like a judge would. This is known as the award in financial matters, which is then converted into a consent order for submission to the court. If you are advised that the outcome is unfair, you can appeal. But if the issue is that one of you simply doesn't like the outcome, then the other can make an application to court for a notice to show cause. Court orders based on the arbitrator's decision are typically issued much faster than those resulting from other non-court dispute resolution. When does it work? This option is usually taken when negotiations between solicitors or mediation have failed and you wish to avoid the delays of court proceedings. You need to be mindful that you need to be clear about the issues to be decided by the arbitrator and also the cost, because you will have to pay for the arbitrator's time and the room hire unless it is dealt in writing, in addition to your legal costs. As a litigant in person, you may find that the court process is cheaper, but you can also be a litigant in person in arbitration. This arbitration is less suitable when there are complex issues or matters of law to discuss, if you want your day in court, and if you need to get evidence from third parties. The top three benefits are that it is said that almost every case that could be litigated can be arbitrated, but it is quicker, cheaper, and better considered because there is proper time for consideration by the arbitrator, the ease of communication with the arbitrator during the process, and also you can get swift interlocutory decisions where required. The next option is collaborative law. With this option, you and your spouse appoint your own collaboratively trained practitioner, and the four of you meet together, where all the advice is given openly and transparently in a non-confrontational way. The lawyers work together to help you sort things out. The meetings are a four-way process with you both setting the agenda for those meetings. Financial information is provided on an open basis, but all the discussions are without prejudice. Negotiations do not take place in writing, and you work together to find an outcome for the overall benefit of the family. Besides your lawyer, other professionals can be joined to the process, such as independent financial advisor, a divorce coach, a family consultant, a child specialist, your own accountant. All these professionals can collectively make up your collaborative team. You and your team have to sign a participation agreement that commits you to try to resolve the issues without going to court and prevents your team from representing you in court if the collaborative process breaks down. This means that everyone is absolutely committed to finding the best solutions by agreement rather than through court proceedings. But it also means that if the process breaks down, you will have to find new representation. This was seen as a problem, so the collaborative light version was created. The process is the same, but you simply don't sign a participation agreement to allow you to keep the same legal representatives in the event that you have to issue court proceedings. What to watch out for? It won't work if there isn't any good faith and honest financial disclosure. You need to make sure that your lawyer will or can work successfully and efficiently with the other lawyer. You need to try to keep the momentum and avoid long gaps between meetings. If there is no agreement and you need to issue court proceedings, you will need to start afresh and instruct a new set of lawyers. But you could opt for the light version, get a neutral evaluation, or agree arbitration. I would say the top three benefits is that the process can be built around your family's individual's timetable and priorities, as the meetings will follow agendas set by you and your spouse. Also, the emotional well-being, and it is an amicable option. And the last one, the private FDR, which is a non-court process whereby a lawyer, who is also often a part-time judge, will hold a hearing that operates just as a financial dispute resolution hearing would operate in the court process. The only difference is that you can choose the date and venue, and you select the private judge who will totally be dedicated to you. It can be arranged within or outside the court process when all the financial information is available. The private judge will properly read and consider the papers and give a view about the strengths and the weaknesses of the positions taken so that the issues can be narrowed and hopefully you can negotiate and reach a settlement. What to watch out for? This method has a good success rate, but it's not recommended if your spouse suffers from narcissistic personality disorder, as they like to play games and prolong the chaos and drama. The cost can be high, as you would be paying for your own lawyers and the private judge. It is a positional process and not solution orientated, and unless you agree otherwise, it is not legally binding, and any discussions, except the offers to settle, cannot be used in any further court action or in arbitration. I have presented many options, and although I have referred to divorce, the same applies to the dissolution of civil partnerships, and married couples can also use some of these options. It is important that you understand how each option works to make an informed decision about what is the best option for you. You may not know straight away. It is a challenging time, and it can be confusing and perhaps overwhelming to decide on the best way forward. And remember, the non-court methods are interlinked and interchangeable. There is no one size fits all. The situation of each separating couple is unique. The decision will depend on your personal circumstances, your vision, your fears, your objectives, priorities. Where are you emotionally? The level of assets, wealth, the level of risk you are prepared to take, your respective personalities. You may need the assistance of a family law professional to make that decision and assess what best suits your personal circumstances. But what if your spouse is difficult? Are they the type of person who are toxic and like to create drama and chaos? If so, they may see any form of non-court option as an opportunity to prolong the process and incur unnecessary legal costs for you. Are they being difficult simply because they don't want the relationship to come to an end and do everything possible to delay and avoid resolution? Uh, in either of these, the use of mediation, a neutral evaluation, or a private FDR with a written unsigned condition that if resolution is not achieved, you will proceed with arbitration as the final backstop can be beneficial. The table on the screen shows all the options I have talked about today and compares the main features. If you would like to discuss how I can help you with your situation, you can book a free clarity session with me through the link on the screen or take a picture of the QR code. You will also have access to my free resources, blog, and social media accounts in that link. If you have any questions, please type them in the Q&A section. Thank you. I hope you find my presentation helpful and I wish you all the best on your journey. Thank you for attending. Bye.